We may finish early, but that's fine. We can use one of the days that we do finish early for review sessions. So start thinking about that. We'll talk about that next week. And if evaluations have gone live in this class, have they? Okay. Well, when they do, look out for that, because I think since this class is early, evaluations might go live. I'll double check. So if we finish early, and we probably will, because there's not that many more problems, and most of the stuff is just substantive things that we should look at in the practice of law. Then we can designate one of those days as a review session. The way I handle reviews is like to get all of the questions from you, just in preparation for the review. So any questions, go back through your notes, look at any gaps that you have, anything that needs to be clarification. It's a good signal to me if I get the same question over and over again, that maybe I need to go back over it again and explain it and unpack it, or maybe something was unclear. So that always helps. And also it helps me sort of divide up the review. So a large part of it, if I get a lot of questions on 1.6, might be on 1.6, or if there's a question on the client as organization, I might sort of organize it that way. You don't have to know rule numbers for the exam or the MPRE. The only reason I reference rule numbers is so that you'll look at them in your rule book. I think your textbook does a good job sort of summarizing the rule in those little charts, but you also have to read the rule itself and the full comments, because that complements the chart. They can't put everything in the chart and they're paraphrasing the rules oftentimes like I do on the board. So make sure you always drill down a little bit deeper into the rule. So we have been talking about duties. And we came out of the attorney-client contest. That was really the first 7 or 8 or 9 chapters. We were talking about the attorney-client relationship and conflict. Then we went to our duties to others, like courts, officers of the court, our duties to the tribunal. And now, when we move into chapter 12, we're going to talk about our duties to third parties. But in our last class, as we finished up chapter 11, we made a number of points in terms of lawyers' duties to clients. We did the child pornography case on 11.5 on page 514. And we looked at a number of options, and we looked at the case in relation to some other cases that talked about the duty to turn over incriminating real evidence. And we know, and we made the point over and over again, that the attorney should not be the depository for criminal evidence. And even those cases that we looked at, Allwell and Morrell, and we sort of drew a line through those cases. And those cases, on some level, said that the lawyer cannot hide this evidence. We were concerned about obstruction of justice. So we had a case called Allwell, and we had a case like N. Ray Ryder, and a case like People versus Meredith. And we looked at those different scenarios, but the common theme that ran through all of them is that the lawyer should not be involved in holding on to incriminating evidence. We also noted that if an attorney goes out and disturbs the scene, that the attorney-client privilege could be lost as well. So we saw a case like that. And so when confronted with those propositions that we had, we looked at the child pornography case and the cases that we decided, and looked at those options on page 515. And we said that we can't keep the computer. We can't give it back to Gardner. And we probably have to deliver it to the FBI because we have a federal crime, and we don't want to expose ourselves or the church to liability. Also, we talked about who our client is. Our client is the church, and it's not a corporate entity, but you could apply the same thing to the church. You report up, so if there was a board of rectors or chaplains or something in the church, and you talk to them, maybe they say, no, we don't want to damage the reputation of the church. So you have a duty under 1.6 if you have real concerns about this doing substantial damage to the organization to reveal. 1.6 gives you the discretion to reveal. You don't have to reveal, but that is one of the exceptions where it would undermine the best interest of the organization. We looked at that, and then we talked about what happened in the real case. The attorney took the laptop and destroyed it, and this was the first time that a defendant was charged under the Sarbanes-Oxley Act for non-corporate crime, and without knowledge of a pending investigation. So it was irrelevant whether or not an investigation was underway or not. Russell challenged this, but he ultimately pled, Russell's the attorney, ultimately pled guilty to mispresent of a felony, 6 months home confinement, $25,000 fine, 250 hours of community service. And we looked at that. So that was on page 514 and 515. Then we talked about the duty to disclose adverse legal authority and made the point specifically that it has to be in a controlling jurisdiction. So if something in the Second Circuit goes against you, you don't have to disclose that, only in the controlling jurisdiction. So if it's a Sixth Circuit case that went against you, opposing counsel doesn't say anything about it, you have to disclose. Talked about refraining from making extrajudicial comments that could undermine the proceedings. Noted that lawyers may not testify as witnesses in cases in which they are handling. That's on page 532. And we talked about fairness to opposing counsel. And that ended chapter 11. Now chapter 12, lawyers' duties to adversaries in third persons. So just because we move beyond the classic attorney-client relationship and our duties as officers of the court does not mean we still don't have duties. And now we're talking about duties to third persons. It's in chapter 12. So, could someone compare 3.3 and 4.1 to me, which is one of the first things that the book does? And the book is trying to get at the overlap between our duties as officers of the court and then 4.1, which talks about truthfulness and statements to others. So what does our text tell us about making comparisons between those two rules? Particularly 4.1a. And 3.3. So this is sort of designed, this little first paragraph on page 540, this is sort of designed to tell you that in practice you have to make sure you look at all the rules because there is some overlap. Now the overlap here is that you have continuing obligations, but look, if we talked about 3.3, we're talking about our duty as an officer of the court. And here we're talking about representation. So just because we're representing a client doesn't mean we ignore everything else. In both of these rules, it says both rules instruct lawyers not to lie. whether you're an officer of the court or you represent your client in dealing with other people, you cannot lie. So if you're talking to a potential witness or an opposing lawyer, that is the sentiment. So one thing you get is that these rules cover a wide variety of practice contexts. So you're not gonna walk out of the courtroom and say, okay, that's good, I was good as an officer of the court. Now I can represent my client any way I want to, and I'll just push my client's interest forward. And I may have to allow the third parties to do that, but I'll do it anyway. No, we want to emphasize that there's overlap. So officer of the court is in that context, but you also have this broader context where you are representing the client and you have to be truthful in your statements to others. Now, the bottom of the page, it says something about 4.1 being different. It differs from 3.3 in that 3.3 bars a lawyer from making any false statements. So as officer of the court, the lawyer, so that was the example where we had the medical report and that was altered. The attorney gave the literal truth. Yes, that's what I told them to test for, but the report had been altered. You make that representation to court, and that's a misrepresentation. So Canada towards the tribunal says that the lawyer is barred from making any false statements. But 4.41 says something different. Prohibits only making materials So what is this difference? Those false statements are of law or fact. So what difference does this term material make in terms of how you deal with third parties? In the course of representing a client, a lawyer shall not knowingly make a false statement of material fact to a third person. Then you have 8.4C. I'll just put, this is a broad misconduct catch-all. So what difference does this make, this term, material? Yeah, go ahead, Tim.
I'm still trying to form the thought in my head, but
That's
with third parties in negotiation agreements, you don't have to tell them your client's bottom line.
material mean? And you're talking about the conventions of negotiation. When you're negotiating with someone, we know that there might be a little exaggeration or slanting. So I guess contextually that's not a lie. But how do we know when we're making something that is materially false that could subject us to liability under the model rule?
Well, if you're giving legal advice to an unrepresented person, that would be, like, say, an unrepresented plaintiff. You need to advise them to get their own independent counsel. You can't give them any legal advice, and you certainly can't give them false legal advice.
Mm-hmm. But, so you certainly have to represent, but we're going to get to this, but if you look at comment 2 to Rule 4.3 dealing with an unrepresented person, that rule doesn't prohibit you from negotiating the terms of a settlement with an unrepresented person. And so long as you explain to that person that you're not representing them and go through it, but that's interesting, because it seems like there's room in the rule for you to even negotiate a settlement with an unrepresented person, comment to that rule. But we'll get to that. But what do people think material means? What, is it something like really, really important? And if it's not really, really important, you can slant the truth a little bit? So maybe a good way to do it is to look at this problem on page 541. And so we've made these distinctions between the rules, and now we're trying to look at what does it mean in our interactions with third parties. We know that lawyers can't lie, but the problem is, what is a lie? So is a lie determined by context? And it seems like comment 2 to 4.1 sort of goes down that road. It says this rule refers to statements of fact. Whether a statement should be regarded as one of fact can depend on the circumstances. So there's no real definition of material. And so we're going to have to look at the context that we're in. The statement of fact can be determined by the circumstance. Context. So what about this problem we have on page 541? So we represent someone who has just been released from prison, and that's a hardship in and of itself. And we're going to have to help our client navigate the transition from being incarcerated to being a fully functioning citizen. And so there are things that we take for granted that may cause this transition to be particularly difficult, moving from the prison to society. You know, little things like being able to go to Kroger or getting gas or having access to travel at the airport, all of those things. And now we are dealing with one of the most basic necessities, food, of course. So we have a man named Jesse Rogers walking into a legal aid office and complaining that he had been denied emergency food stamps. He had been released from prison the prior day. Prison authorities had arranged temporary transitional services, lodging, food, bare minimum cooking facilities, small amount of cash, told him he could receive food stamps at a welfare office, and that a social service agency would assess him for employment the following week. Now, the prison authorities certainly could expect that a newly released person would be eligible for food stamps. There are statutes and regulations that create this entitlement. And there is a provision that is there for immediate need. And so when someone has immediate need, they don't have to go through all of the formalities that can serve as an obstacle to receiving aid. Getting a picture ID, getting proper documents. But this application calls for various documents: proof of residence, social security card. The one thing that our client does not have is a picture ID. And it's going to take a while, maybe at the very least 5 days. Now, the regulations have in place a waiver provision where we could just waive that, but the office could waive that, and our client could get the assistance that he needs. If we can explain this emergency circumstance and there is a reasonable explanation, then we should be able to receive this aid. Nevertheless, time and time again, the worker at the social service agency refuses to give any benefits until our client is able to present a picture ID. So upon hearing this, we try and find a way for our client to get the aid that he needs. And you see on page 542, we decide to have a paralegal call and pretend that the district manager is on the phone, because we want to get someone in that office to come to the phone so that we can talk to him. Teresa Taylor is her name, and she's the welfare department district manager. We pretend that the district manager is on the phone. Within seconds, the office director comes on the line. After previously saying, well, we can't find them, unavailable, so we have our paralegal call with a secretarial tone and say, Teresa Taylor is on the line for you, and then the worker comes immediately to the line. Feigns ignorance. Of course your client is entitled to this assistance. A little bit irritated when we reveal our identity after we get him to come on the phone, but we fully explain our identity, what we need, and then his tune changes. The director says, oh, he's in immediate need. He should have told us that. And he finally agrees to give the food stamps that afternoon. So this whole problem is premised on what is a lie. And I guess we pretended to be someone else in order to get a particular result. So is that a lie? So you have two questions there on page 542. A Massachusetts rule in effect at the time these events took place imposed the same obligations that Rule 4.1 does and 8.4c. Did the attorney violate those rules? And if he did violate the rules, did he do the right thing? So 4.1 says we can't make a false statement of material fact to a third person. We're dealing with that. And then 8.4c says we shall not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. So was this conduct a violation of the rule? Don't think about it in terms of the result yet. Just think about, is it a violation of the rule? Ms. Moore?
I don't think it's a violation of Rule 4.1.
Okay, why not?
Because I don't feel like what they did is misrepresentation of the material fact. Because it doesn't have to do directly with whether or not he's eligible.
Uh-huh. But Teresa Taylor isn't on the line though, so is that, how do we look at that?
Well, that's not material, so whether or not he's eligible.
Okay.
Who's on the line.
Whether who's on the line or not, he's still entitled to this under their own statutes, and they're not giving it to him. We need to talk to somebody, so we bring him on the line. So that's not material. So what does that say about this definition about what is material? It gives us discretion to look at the context and determine whether a statement of fact is material or not. But what makes the fact that Teresa Taylor is not there something that we're not really concerned about? We're concerned about the aid coming to our client. But what about that misrepresentation? And it's clearly a misrepresentation. She's not on the phone. What makes that not material, so we're not really concerned about it?
It doesn't change the underlying circumstances of the case.
Yeah.
So he's still eligible.
Right.
Even though it is a misrepresentation, he's eligible whether or not he falls about that.
Okay, that's good. So, but now what about this broader question? Just all misconduct. Prohibits lawyers from engaging in deceit, misrepresentation, dishonesty, or fraud. How do we get around that? Because that's interesting. You got these two rules. I think you're right about 4.1. It's just material facts. But then you have these other rules that are a lot broader. You know, our candor towards the tribunal doesn't make that distinction, and 8.4 doesn't either. It just says everything almost. So have we violated 8.4? That's the harder question, I guess. Yeah, have we violated 8.4? Or is 8.4 talking about something different than the conduct that we were involved in? I mean, it doesn't state it clearly, but maybe it's a little bit different than what we did to help our client. Yeah, how do we know, I guess, if something is bad enough to cause us to be subject to liability for doing something like this? So notice this, one way out of it, no, look at comment 2 to rule 8.4. And this is talking about illegal conduct, so it's not totally on point, but it might help us a little bit. Many kinds of illegal conduct reflect adversely on fitness to practice law, such as offenses involving fraud, the offense of the willful failure to file a tax return. So it seems like we're talking about some willful misconduct that's connected to something underlying that might be illegal, and we didn't do that in this particular hypo. However, some kinds of offenses carry no such implication. Traditionally, the distinction was drawn in terms of offenses involving moral turpitude. So what we did here isn't moral turpitude, there's a higher purpose, but then the drawback is we as lawyers are determining what is morally acceptable. But on some level, this is close to the statements that we make in negotiations, and everyone knows in context that there might be slanting of the truth. In this particular context, we know that administrative agencies often put up barriers, and this is one way to get through that. And so there's something else that runs through this rule too. This is back in 8.3. If you have to report every type of violation, that would really undermine the vitality of a self-regulated profession, which, in other words, we want to report and discipline the most significant type of infraction of these rules. And this certainly isn't that case. And on some instances, we had to pretend in order to get an answer because our client really needed this in terms of sustenance. And we're going into a long weekend, and it's going to take us forever to get the ID. So once we get the person on the phone and we identify ourselves, that's fine. We just need to get someone on the phone, and that's what we did. Now look at this other example, page 543. How is that different? You see that example of David Austin? He's holding on to a valueless check for his client. The client is the seller. The buyer wants some assurance that repairs will be made. So they ask as a component of this transaction that the seller put up $10,000, sort of in an escrow account to cover any upcoming repairs that will have to be made before the property is sold. Attorney accepts a check, in quotation marks, from the client. The client tells him that the check is valueless. The attorney holds on to that valueless check until the transaction goes through. And then maybe, two months later, he opens an escrow account and deposits a good check when he receives it. How's that different than lying and saying the district agent, the district manager is on the phone, and here we're holding a valueless check. But we do put the money in 2 months later, and the transaction goes through. No one's harmed except for us advancing this falsehood. What's the difference between those two cases? It seems like we really want to accept, we can accept the conduct of the lawyer when we get someone to come to the phone by representing that the district manager is on there. We seem fine with that because we get the result. But what about this valueless check? I mean, not a major penalty. I mean, any penalty is major, but this attorney was publicly censured. So what's the difference between? Yes, go ahead.
I think the difference is that the lie is what got his client to win what he wanted. Like if he hadn't lied about the check, then the buyers wouldn't have bought it.
Okay.
So it went to the actual substance, the materialness of the whole agreement.
Okay, so good. So even though we don't have an example, a definition of what material means, everyone is saying it has to do with something of substance, something that impacts the outcome, something And so what sort of distinguishes this example from what we did is this transaction would not have gone through. This transaction would not have gone through without this type of misrepresentation. And so that is why we say that this client, that the attorney assisted the client in committing fraud. Valueless check secures the transaction. That certainly is a material to the outcome. And a false statement to third parties, and we are prohibited from doing it. So on page 544, let's take this a little bit further. Ms. Shaw, tell me, how is testing different? So we know that a certain upscale neighborhood is prohibiting people of color or even people that they deem to be poor from coming in. They use a lot of neutral regulations and income, but we know the impact is disproportionately on people of color and poor people. And so we want to prove that, so we send out some people pretending to want to live in this neighborhood. Now, is that a misrepresentation?
No, I don't think so.
Okay, well,
Because, I don't know how to say it, like.
so I come to the neighborhood and I say, my name is Jeremy Burns and I want to buy it and I have a lot of money. I have like $1 million in my bank account and I want to live. And I don't have $1 million in my bank account and my name isn't Jeremy Burns.
I mean,
but
you're not, it doesn't change the fact that they're discriminating though.
Okay.
You know, like you're just using that as a way to prove it, like you're not
Okay.
really changing, maybe.
So, good. So why is it not a material statement? Yeah.
I mean, because it's not changing the truth of the situation.
Okay, so we're kind of building upon what you and Ms. Moore said, that we're looking, if the situation is ongoing and we're using some type of covert activity or something that could be viewed as a lie to uncover the truth, that really isn't a misrepresentation of material fact. The discrimination is ongoing, the denial of welfare and social security benefits is ongoing, and nothing that we're doing is changing that, so it's not really material. And so these things are gonna happen anyway. The only thing we're trying to do is investigate and uncover what is actually occurring. And so that's what the example says, that testing is permissible. We wanna substantiate the claim of discrimination. So on some level, it's connected to what we have to do as attorneys. We talked about meritorious claims. There has to be a good faith basis in making these claims. And the only way to do that is to have some form of proof. And this is probably the most difficult area to get proof in, so this is accepted in terms of a technique to uncover wrongdoing. Now, this leads us to another comparison. We're comparing all these things to work with material. What about the Beatles case and the Gaddy case? So the Beatles case, no violation. There you have people posing as Beatles fans who wanted to buy these stamps that had infringed copyright, but you still had a group of stamp buyers who were still eligible because they were a part of the original transaction. Further sales were enjoined, but there were some remaining sales to be made to people who still wanted the stamps. Had some people pose as potential stamp buyers who would not be eligible to receive any stamps, and they sold them the stamps anyway, and that shows that this is wrongful conduct that continues. And those sales of the John Lennon stamps were enjoined by the court. Copyright infringement. And so there was this notion that the attorney violated 8.4C, misconduct. He posed as a buyer of stamps, but the court concluded that Weber should not be held in contempt. Weber did not violate the rule. And so that is one scenario. And then in the Gaddy case, there was a violation. I won't go into the, but so how do you compare those two cases? Why do you have no violation? I'll just put pretending to be a stamp buyer like a test, but. Tending to be done. So why do you have a violation in one and no violation in the other? He pretends to be a chiropractor and falsely claims to be a doctor. In the footnote 8 on page 545 says, he says that that's not really false because he is a Juris Doctor. So a doctor is a doctor. So we have violation of the rule. So what's different? Yeah, so two scenarios, go ahead.
I mean, I feel like it's like illegal to pretend to be a doctor in most, if not all states.
Mm-hmm.
So that's probably a big difference, like if he was breaking the law.
And so maybe another way of saying that is this misrepresentation is directly tied to some illegal conduct. And so how do you distinguish the Beatles case?
I mean, if you're a stamp collector, I don't think it wouldn't be illegal to pretend to be a stamp collector. And there's no like certification probably for it.
And there's no what?
I don't think there's like a certification as like a stamp collector.
Mm-hmm. Ms. Paula?
Well, in the Beatles case, there was already a suit filed when they did the and then they did the investigation, and then in the Gaddy case, it was just kind of like a tip, and he was seeing if they could file something against that company, so that could have played a role too.
Okay, how? Sort of expand that further from what you said.
Well, in the Beatles case, there was already a suit being filed, so in that sense, the investigation they were doing could have been pertinent to the case.
Okay.
So even though you're not supposed to lie or anything like that, it kind of was to further the case and get information that you wouldn't have been able to get otherwise.
And good. And so maybe that's the only way that we can prove whether or not this injunction is being enforced and paid attention to, is if we have someone pretend to buy stamps, and if they get them, that shows that this type of conduct is ongoing. What about Guy?
Well, he got a tip that a company was possibly giving false recommendations or having false training, I guess. But in that case, there wasn't any suit filed yet. It was investigating to see if you could file a suit.
Uh-huh.
And so they weren't really furthering, they weren't furthering their investigation for the claim that was happening because it hadn't happened yet.
Okay.
So they were just kind of seeing if they could file something.
Okay. And so what makes that more of a misrepresentation in the Beatles case? That's good.
What was the question?
Yeah, what makes that more of a misrepresentation and violation than the Beatles case? Sort of tying it in, so you're saying there's a suit and an investigation here. This is probably the only way we can prove it, and this falls in line with the tester cases. So that's fine. But you're suggesting that this goes beyond that because no suit was filed. They're investigating on a hunch. And so this misrepresentation in the Gotti case is much more severe than the Beatles case. And I'm asking, what makes it much more severe?
Well, I would say the Beatles case, you're doing it in the interest of your client since there was an injunction filed.
Okay.
And then in the other case, you don't really have a client yet, you're just seeing if you can sue someone.
Yeah, and so it looks more like you are totally misrepresenting to third parties. And so notice, this is good, on page 546, Gotti violated the rule by misrepresenting his identity and purpose to deceive Adams and Becker. So he gets publicly reprimanded. But one thing about this ruling really goes far. It says even prosecutors could not make false statements or direct others to in order to investigate. So that caused some concern among law enforcement and prosecutor-directed undercover investigation. And so then there was some litigation in Oregon, which is where this happened, and there was the notion that government and private lawyers can supervise covert activity, if they were government lawyers. It still was murky about whether undercover investigations by non-government lawyers was applicable under this rule. But if you look at the last paragraph on page 547, I think this is a good way to resolve it. It says, no disciplinary case seems to have addressed the issue, but one bar opinion talks about endorsing dissemblance by investigators. So endorsing some type of subterfuge or false statement or misrepresentation, if it is in the context of investigation. So you're investigating violation of civil rights or intellectual property rights. There has to be a good faith belief that a violation is taking place or will take place imminently. So notice that ties into Ms. Paula's point that there is some type of discernible injury or issue that we are trying to investigate, not just making misrepresentation. 2, the dissemblance is expressly authorized by law, and the evidence sought is not reasonably available through other means. And the lawyer's conduct and the investigator's conduct do not violate 4.2, where you have someone represented by a client. But if you look at 4.2, there are 2 comments that also help. Comment 5. Now this is communications authorized by law. And so maybe your client is trying to exercise a constitutional right, and this is the only way to discover whether or not that right has been violated. That sort of gives support to the theory that you can test whether or not discrimination is actually occurring. Or comment 8. So you can't do something where the lawyer has actual knowledge of the fact of representation. That's a different scenario, so you can't make misrepresentations there. But this seems to support the proposition that you can investigate. And the way that we distinguish is that the investigation was connected to something that you're trying to do for a client, particularly testing in the violation of a civil right or constitutional right. What about starting on page 548? Facebook, Google, and Twitter, and all that. So if you are a lawyer, can you go on Facebook and pretend to be somebody else in order to get information? Say you're a family law attorney and you're doing some divorce work. You get on Facebook, you set up a sort of a profile, send a friend request to the client on the other side of the V in this divorce action, send a friend request, not with your identity, but you make up an identity, just want to be friends, and you want to use this sort of as a a door to any information that you could use against that client, that you know is represented, against that client in the divorce proceeding. Can you do that? Wide open, electronic, not really regulated. So do it. Ms. Harper, go ahead.
I'm gonna say no,
Why not?
because you shouldn't.
Just sounds bad, or?
Really shouldn't even be talking to people in the great period, regardless of whether you're misrepresenting your identity or not, without their counsel present. So you're already violating one of the rules of professional conduct.
So you can't, well, so I guess it's some type of fraud if you sort of pretend to be somebody else on Facebook. People have alternate identities. What about that?
When you say alternate
Like
identity-
if I wanted to be on Twitter and I wanted to sort of preserve I wouldn't use my real name. I would make up something, and then just be active that way. And then what happens if I sort of fall into some information that I could use against someone that I'm in litigation with? Is that okay? Yeah, what do these materials say about lawyers using deception in order to gain information? And I think you were right when you said you have to be very careful if somebody's represented by counsel. And even this second question on page 548 says, a lawyer shall not communicate about the subject of representation with a person the lawyer knows to be represented by another person. So you couldn't create a false identity, reach out to somebody that you know is represented in order to get information. That would be a misrepresentation, of course, in your statement to others. It would be misconduct, of course, and it would be communication with a person represented by counsel. Because you have that unfair advantage. You are the attorney, you know the person is represented, and you're going around that representation where that person could get advice in order to impose your agenda on that person. So now, even the top of the page where it says, may a lawyer investigating a matter friend a witness or prospective defendant on Facebook or other social networking site to search for information that might be helpful to the lawyer's client. You have to use your real name and profile. A lawyer cannot use deception, and that goes in with what we were just talking about, that you can't communicate with someone that you know is represented. Also, you cannot falsely disguise your identity in order to have that advantage. So the top of the page says you must use real name and profile. Lawyer may not use deception. Now, that doesn't preclude the lawyer from using Google as an investigative tool. That's permissible. People can look that up. But let's go through comment 2 to Rule 4.1. Sort of mentioned it in passing, but I just want to make sure we made this point earlier, that a statement of fact can be determined by circumstances and context. What does the comment say? How do you read that comment? So you have this sort of long-winded rule, and then the last sentence sort of gives me pause. This is comment 2 to Rule 4.1. Lawyers should be mindful of their obligations under applicable law to avoid criminal and tortious misrepresentation. After you have this long rule about negotiations being different. So how do you deal with that? So you get on some level that statements, the context may determine materiality. And so that negotiations are different, they're an exception, because within that context, people make a lot of comments. And everyone knows in terms of how negotiations go that there's give and take in terms of what is true and what is not true. Now, you see on page 550 that some professors have criticized comment 2 of 4.1 as really enshrining something that is unduly adversarial. I mean, in other words, if you give attorneys this much discretion and leeway, they are going to push the rules to the limit. So mere puffery and those type of misrepresentations can become much more in an adversarial context. And that's even suggested on page 551. Professor Minkle-Meadow suggests that tactics sometimes lead to subsequent claims of misrepresentation. See, and she's really talking about this expansive notion of lawyers saying this is how the game is played. These are the terms of engagement. And so there is some justification from us as lawyers that misrepresentation in this particular context is fine. And then the question is, and this there's no answer to this, but we sort of have it baked into our rule. Why should accepted convictions of advocacy prevail in an ethics code? And she's suggesting that there should be something much stronger that regulates lawyer behavior instead of encouraging the very type of behavior that we're trying to regulate. So what about this question about lying in a negotiation? That takes us here on the bottom of page 551. So we have this scenario. Settlement negotiation, we know that our client is willing to settle up to $100,000, right? So the plaintiff asked us, we represent the defendant, the plaintiff asked us, will your client pay $90,000? Now the answer to that is yes, that's the truth, because our client gave us a limit of $100,000, but we know we can get a lower payment for our client, and so we offer $50,000 and no more. That's the best I can do. I've talked to my client, that's the best I can do. So that gives us a range, I guess, in terms of negotiation of $50,000 to $90,000. Now, is that a misrepresentation? It's a lie to say, $50,000 and no more. We know that we can go up to $90,000, but we don't say that. We say $50,000 and no more. You will have lied. What will you say? What about that? Is that a lie or what? Yes, go ahead.
I would say no, probably, because in comment 2, it actually talks about negotiation. Like, it says certain types of statements are ordinarily not taken as statements of material fact.
Mm-hmm.
So, I guess that kind of talks about how there's like an understanding between the parties that that's going to go on, and both sides are kind of free to do that, as long as it's like a normal negotiation technique, I would say.
So what do you mean by a normal negotiation technique? That's interesting.
I don't really know.
So, and this illustrates the point. We're letting, there's probably no resolution to this, but we're letting convictions of advocacy determine the scope and impact of the rule. So we're saying everybody does this, we know it. This is a context where we allow some misrepresentation. This is the way that the game is played, and this is advocacy for our client, and we're talking about $50,000 to $90,000, and any way we can get a savings for our client, that is good. And I guess that's the answer, but you're gonna have, and practically, situations where lawyers abuse this. And I guess the response to that is that the limitation is that you work for the client, you have a scope of representation, you have communication, we are the agent of the client, and we take what the client wants to do and pursue that within the context of the rule. Now what about this? What happens if this happens to you in practice? On page 552. Sending a lot of things through fax, Xerox scanning, and 4.4b. This is respect for the rights of third persons. So if you receive a document, this is a blockbuster document. You've been looking for this in the document production. Opposing counsel has been putting up barriers within the rules of discovery, but you know that this document is there, and then for some reason it inadvertently gets sent to you. What do you have to do? And in the context of what I just described, you've really been trying to find this document, so you know if you get it electronically that it was an accident. So what do you have to do under 4.4b?
You have to notify the lawyer that it's sent to you.
Yeah, and then anything else? Notify the lawyer, can you keep it, or you have to give it back? Or you already know anyway, so it doesn't matter.
Isn't that like a jurisdictional split? Like some judges will allow you to.
Yeah, but just in the context of the rule, what can you do? It just promptly notify the sender. Does this rule do anything? A lawyer who receives a document relating to the representation of the lawyer's client and knows or reasonably should know that the document was inadvertently sent shall promptly notify the sender. So we know that this is a problem because this is the document that we've been looking for. This is the document we've been looking for. And so we notify the sender, and then that's it. Look at comment 2 to Rule 4.4b. What does that tell us? This is an interesting rule because it seems like something bad happens to opposing counsel. That's too bad. You notify them, and then that's that under the rule. So we have shall notify the sender. What about comment 2? It's long, but it's sort of first. So sort of in the middle of that paragraph is where you want to go. Look at this. If a lawyer knows or reasonably should know that such a document or electronically stored information was sent inadvertently, then this rule requires the lawyer to promptly notify the sender in order to permit that person to take protective measures. I don't know what those protective measures would be. So once this is out and you notify, you already know what's in that document. Now notice this. This is my question, does the rule do anything? The next sentence says, whether the lawyer is required to take additional steps, such as returning the document or deleting the electronically stored information, is a matter of law beyond the scope of these rules. As is the question about whether or not a privilege has been waived. So I guess that's your point, Mr. Baker, about splitting the jurisdictions. What would you do?
Oh, I mean, I would say it's fair game, like, send me, you know, whatever, your limits of liability, I've already seen it.
Yeah, that makes me, that's devastating. You're a young associate on the other side. Accidents happen, but I guess this comes out, and what I'm suggesting is this rule really doesn't, you're honest by saying, I got this, maybe you really didn't do it, but now you have it, and then the question is, what do you do with it? And then the comment says, we don't really know. You just notify the sender, and that's that. Similarly, this rule does not address the legal duties of a lawyer who receives a document that the lawyer knows or reasonably should know may have been inappropriately obtained by the sending person. So notice this, that may not be an accident. Maybe somebody goes out and they like your litigation work, and they go out and steal some documents that you've been trying to get. They scan them and send them to you. This rule really doesn't answer that. And so the rule sets up a duty to disclose, but any further remedies are left up in the air. And that's interesting. It just says that your duty to these third parties is simply to disclose. Respect for the rights of third parties. Jump over to 558. I want to sort of make some points about this. We're going to deal with dealing with an unrepresented person. But before we do that, we have this case, the Messing case. And so you have a scenario where you have Kathleen Stanford, and she's suing Harvard University Police Department for gender discrimination. And so what drives this is, in the course of the investigation, her attorneys talked to Harvard employees without first notifying Harvard's counsel. And none of those employees had management responsibility, but two of them did have supervisory authority over Messing. And so what we're looking at now is this rule that we have all the way on page 561, dealing with unrepresented persons. And we're going to look at the rule itself, but there's a comment that sort of helps us understand. So when we have this rule dealing with unrepresented person, we want to make sure that we don't use our power as attorneys to have an unfair advantage. And so, since the beginning of this course, we've talked about preserving that attorney-client relationship, and this is what this rule is intended to do. We don't want some outside force coming to disrupt the attorney-client relationship. And so when we deal with Rule 4.3, and you have the chart on page 561. So what do you have to do under this rule, 4.3? You had to paraphrase it, but you also have the rule itself. Let's sort of compare those. Let's do 4.3 first and then go back and we'll do message. What do you have to do when you're dealing with an unrepresented person?
You have to tell them that you're not their lawyer
Uh-huh.
and you can't appear disinterested.
So what does that mean? You can't appear disinterested.
You have to disclose that you're partial
Mm-hmm.
and may have, because of your client, have contravailing interest.
Yeah.
to the other.
So notice, your duty under this rule is to make sure that any misunderstanding by the unrepresented person is corrected. So you can't sort of pose and say, well, I'm just giving you some neutral advice, or I don't have any interest in this, I'm just telling you. You can't do that. So first and foremost, I'll put it like this. The lawyer must address any misunderstanding by the unrepresented person. And I'm just paraphrasing the rule, but that means if you break this rule apart, you have shall not imply that the lawyer is disinterested. The language here is reasonable efforts to correct the misunderstanding. So you know something like, oh, we're on the same side, kind of, right? We're trying to do the same thing. I know that you're opposing counsel, the other person's lawyer, but I just think we're trying to get the same thing out of this, right? And so you have to say no. Shall I give legal advice? So, if you look at comment 1, you have an unrepresented person who's particularly vulnerable, and what this rule is trying to deal with is a lawyer using her skill and power to undermine that unrepresented person's interests. So the lawyer will typically need to identify the lawyer's client, and where necessary, explain that the client has interest opposed to the unrepresented person. And so we've seen this before too, where people are in a corporation And they erroneously assume that just because you're general counsel, you represent everyone in the corporation and not the organization itself. That's an example of explaining the proper role of the attorney. Now, what about negotiating terms of a settlement? So one important thing, and this is a long comment, I won't read through all of that, but comment 2 makes distinctions about the types of things that a lawyer has to tell the unrepresented person. So if you look at comment 2, and the basic distinction is this: the rule distinguishes between situations involving unrepresented persons whose interests may be adverse to those of the lawyer's client and those in which the person's interests are not in conflict with the client. So that's what triggers it. And I'll put comment 2 there. Is a distinction between adverse interests and common interests. So there's certainly a duty to disclose if you represent someone, the unrepresented person thinks that everything's fine. You tell them you are not impartial, your client's interests are opposed to their interests, and those disclosures have to be made because the interest is adverse. But if those interests are not in conflict, that's different. You see sort of the last half of the rule. It says that a lawyer, the rule does not prohibit a lawyer from negotiating the terms of a transaction or settling a dispute with an unrepresented person. And I guess the reasoning goes is that both parties, no matter what, want a compromise to this particular situation. And so that's a distinction. It's not adverse. Those interests aren't in conflict, I guess, at least superficially. And the rule allows for that type of negotiation. But be careful with that, because I think that could sort of blossom into a situation where there is a conflict, particularly if the negotiation isn't going well, interests diverge, and you no longer have that common interest. So I think as a general principle and statement, this comment is certainly true, but as with anything, fact-specific analysis has to be made in terms of whether or not a disclosure has to be made about adversity to the unrepresented person's interest. So that's the unrepresented person. And then 4.2 that we've been referencing throughout is a person represented by counsel. So a lawyer shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has consent of the other lawyer or is authorized to do so by law or court. So this scenario, the Messing case, deals with that scenario. And I just set it up. Kathleen Sanford is suing Harvard, gender discrimination. She's represented by the Messing law firm. They interview employees of Harvard Police Department without notifying Harvard's counsel. None of these employees have managerial authority, but 2 of them have supervisory authority over Stanford. So what does the court conclude in that? And then that's going to take us to what ultimately happens in terms of how the rule is drafted and what comment 7 says. So this rule tries to balance. It's sort of like when we're talking about attorney-client privilege. This court sort of construing what 4.2 means says, because Harvard wanted to say that the law firm violated 4.2 by interviewing these Harvard employees without permission of the general counsel. And the trial court believed that and ordered the firm to pay $94,000, but then the firm appeals to the highest court and reverses. And the high court said there has to be some balance in terms of access to this information. You don't want to totally insulate this information from any type of scrutiny. So the court banned contact only with those employees who have binding managerial authority. So even the interviews of the Stanford's 2 supervisors was permissible because they don't have any managerial authority. They can't bind Harvard. The only thing that they can do is evaluate her performance. You look at the top of page 560, you have an amendment. The ABA revised what is now comment 7 to Model Rule 4.2 in 2002, just because of a number of cases like messing that courts were interpreting throughout the country. What about comment 7? It tries to, the Messing case talks about managerial authority and who can be contacted without first having to contact counsel. So comment 7 tries to clearly say who the lawyer can contact without getting consent of counsel. So we're talking about an organization, a represented organization like Harvard. The rule prohibits communications with a constituent of the organization who supervises, directs, or regularly consults with the organization's lawyer. So if there's some regular consultation with general counsel, this rule is saying that that is conduct that can bind the organization, and therefore you need permission to talk to that type of employee before talking to them. Or has authority to obligate the organization with respect to the matter, or whose act or omission in connection with the matter may be imputed. So any person who has the managerial authority that we talked about in Messing, who regularly consults with general counsel, who has conduct that can bind the organization, that person cannot be talked to without first getting permission from counsel. Anything that can be imputed to the organization for purposes of civil or criminal liability. Consent, notice this sentence, consent of the organization's lawyer is not required for communication with a former constituent. So somebody who quits the organization and you want to interview them, that person is no longer connected, their conduct cannot be imputed to the organization, they're no longer communicating with general counsel, and so it's fair for you to contact that person without consent of counsel. Also, you could have a scenario where apart from the general counsel, some constituent of the organization might have their own attorney. Notice this, if a constituent of the organization is represented in the matter by his or her own counsel, the consent by that counsel to communication is sufficient for purposes of the rule. So you don't have to go up layer by layer. If you know someone, a constituent of the organization has representation, that's who you contact because you know that they're represented, and that is how you will get consent. So comment 7 really tries to explain what happens in the Messing case. So it's just a way of saying anyone any constituent who has the power to bind the corporation cannot interviewed without consent of counsel. So look at comment 7 for the specific wording, but this is a paraphrase of that. If you know that anyone that you're talking to has the power to bind the organization, either by imputation or directly talking to the general counsel over a series of time during the job, any constituent who has the power to bind a corporation cannot be interviewed without consent of counsel. That's what comment 7 generally says. So we want you to have full access to factual witnesses, but we also want to balance those constituents that may be able to impact the organization. The lawyer also must have actual knowledge of the fact of representation. So when you're in a corporate context, of course you have knowledge because you know that that organization has general counsel. Okay, we'll stop there and we'll finish up this chapter because there's only one more problem, the prosecutor's masquerade. We'll start with that and then we'll start chapter 13.
Same. I thought it was over there.
My feet are lit. Oh my God.
I think it's just from the ball. You want to take that?
Oh, yeah. I'm gonna, I don't want to problem, but I usually send out a model exam. So you just let me